You die without a will, you don't actually get to decide who gets your house, your savings, or your stuff. The state has already decided that for you years ago, before you were even born. And almost 70% of Americans are about to find that out the hard way. Hey, and welcome back to Estates Made Simple. Today we're breaking down what actually happens when someone dies without a will, sometimes called dying in a state. This isn't theoretical. This happens to regular families constantly, and most people have no idea until it's already happening to them. We're going to go through this step by step in plain language, no legal jargon, so that by the end of this, you'll actually understand how this works and what you can do about it. Number one, the state, not your family, decides who gets everything. Every state has what's called intestate succession laws. These are basically a fill in the blank inheritance plan that the government has written for you, whether you wanted it or not. It usually goes your spouse first, then kids, then parents, then siblings. But here's the part that surprises people. Your spouse often doesn't get everything automatically. In many states, if you have kids, your spouse might only get a portion, and your kids will get the rest, even if your kids are toddlers. That can mean surviving spouse suddenly becoming the co owner of the family home with a 7-year-old, at least on paper, which creates real complications if that spouse ever wants to sell, refinance, or move. And these rules aren't the same everywhere. Some states split things differently, depending on whether you're in what's called a community property state. So the exact number really does depend on where you live. This is also where things get genuinely messy for the second marriage. If you remarried and your kids from a previous relationship, your current spouse and your kids from the first marriage could end up splitting your estate in ways neither of them expected, and possibly in ways that creates real tension between two sides of a family who already have a complicated relationship. Number two, your stepkids and your unmarried partner can get nothing legally. This one catches blended families off guard constantly. Stepchildren are not automatically included in intestate succession in most states. If you've helped raise a stepchild for more than 15 years but never legally adopted them, the law may treat them as a stranger when it comes to your estate. Same goes for a partner you've lived with for years but never married. No marriage certificate usually means no automatic inheritance. No matter how long you've been together or how much you've built as a household, people sometimes assume that living together long enough creates some kind of automatic legal protection, similar to a common law marriage. But most states don't recognize that. And even in the handful that do, the requirements are stricter than people expect. If you want a partner you're not married to, or a stepchild you never formally adopted, to inherit anything from you, a will isn't optional. It's the only thing that should happen. Number three, jointly owned property doesn't always work the way people would assume either. A lot of married couples own their home or bank accounts jointly, which can actually help avoid some of these problems, since jointly owned property with the rights of survivorship typically passes directly to the surviving owner without going through probate at all. But this only works cleanly when the ownership is set up correctly, and it gets complicated fast outside of a simple marriage. If you co own property with a sibling, a business partner, or an adult child, the rules around what happens to your share can vary depending on exactly how that ownership was structured on the paperwork. And a lot of people genuinely don't know which type of ownership they actually have until this becomes a problem. Number four, if you have minor kids, this gets even more serious. Most people assume that if something happens to them, their kids just automatically go to whoever feels like the obvious choice: a grandparent, an aunt, or even a close friend. But here's the actual rule: if one parent is still living, that parent automatically keeps custody. No court process needed for that part. But if both parents are gone, and there's no will naming a guardian, a court has to step in and decide who raises your child, based on the court's judgment of who's best suited. Not necessarily who you would have picked, but who is best suited. And here's the part that almost nobody knows. Even when a surviving parent does keep custody of the kids, that parent isn't automatically in charge of any money or property the kids inherit. The court still has to separately appoint someone to manage that inheritance until the kid turns 18. And that person doesn't have to be the same parent. Naming a guardian in a will is one of the simplest and cheapest things you can do. And it's the one thing on this list that has nothing to do with money and everything to do with who actually raises your children if the unthinkable happens. Number 5, the court picks who's in charge of your finances, and it might not be who you would choose. Without a will, there's no named executor. Instead, a probate court appoints what's called an administrator, usually a close relative, to handle paying off debts and distributing what's left. That sounds fine until you remember that close relative could be an estranged sibling, an in law that you don't get along with, or literally anyone who shows up first and asks the court. And once someone is appointed, they have the real legal authority over your accounts, your property, and your final bills, which is exactly why this matters more than people assume. Okay, and I know we only said we were going to do 5 here, but I'll throw in some bonus ones here for you at the end. So moving on to number 6. It takes way longer and costs real money. When there's a will, probate can still take time, but it's usually faster and cheaper because everything's already decided. Without one, the court has to verify who the legal heirs even are, which can mean tracking down relatives, ordering documents, and resolving disputes. That can stretch the process out for months, sometimes over a year. And every month it drags on, court and administrative fees are quietly draining the estate before the family even sees a dime. Meanwhile, bills like the mortgage, property taxes, and utilities on the house don't just pause because the estate is tied up in court. Someone is still having to cover the bill for that, whether it's a family member or it just gets taken directly out of the pocket of the estate. And often these charges never get reimbursed. Finally, moving on to number 7. Not everything you own actually goes through this process. And that's both good news and a trap. Some assets skip probate and intestate succession entirely. Life insurance with a named beneficiary, retirement accounts, and bank accounts with a payable on death designation go straight to whoever's name is on the form, regardless of what a will would have said. The good news: this can be fast and simple. The trap: if you forgot to update that beneficiary after a divorce or a new marriage, that ex-spouse from a decade ago might legally still be entitled to your account, even if everyone agrees that that's not what you would have wanted. This is one of the most overlooked parts of estate planning, because people assume their will controls everything, when in reality, the beneficiary from a form you filled out years ago at a job that you don't even work at anymore might be the document that actually decides where your money goes. So let's just recap all of this, because that was a lot of information. The state decides who inherits. Stepkids and unmarried partners can be left out completely. Jointly owned property doesn't always pass the way you would assume. Your kids, guardian, and the person managing their inheritance might not even be the same person if you haven't named one. The court picks who's in charge of your finances. The whole process slows down and costs way more money, and certain accounts skip the process entirely based on outdated forms you might have forgotten about. None of this requires anything dramatic to happen to you. It just requires you to do nothing. And the fix isn't complicated, and it doesn't require a $2,000 lawyer for most people. A basic will costs very little, sometimes nothing if you qualify for free legal aid. And even a simple one gives you control over the parts that matter the most. Who raises your kids if something happens to you? Who gets specific things you actually cared about? And who is legally allowed to make decisions on your behalf? Beyond the will itself, it's worth taking 10 minutes to actually check the beneficiary designations on your retirement accounts, life insurance, and your bank accounts, since those forms can quietly override your will entirely, even if they're outdated. If you've gotten married, divorced, had a kid, or changed jobs since you last looked at these forms, there's a real chance that they're still listing the wrong person. The real first step before any of that, though, is just knowing what you actually own and where everything is. Your accounts, your policies, your passwords, your wishes, written down somewhere for your family, so that they can actually find them. A lot of families don't struggle because the legal process is complicated. They struggle because nobody could even figure out what accounts existed in the first place. People sit on retirement accounts from old jobs, life insurance policies they forgot they even had, or savings accounts at a bank that doesn't even have a branch anymore. And none of that gets found until someone stumbles across an old statement months or years later. If it gets found even at all, money that nobody knows exists can't be inherited by anyone, no matter what a will says. And this doesn't have to be done all at once. And it doesn't even have to be perfect. Even a rough list scribbled down somewhere safe is better than nothing. Because the goal isn't a flawless legal document. It's giving your family a starting point instead of scavenger hunt during one of the most stressful and hardest weeks of their lives. So to help you out here, I put together a free checklist that walks you through exactly what to gather before you even think about talking to a lawyer. It's linked right down below this video, and it only takes about 10 minutes to fill it out. And it's the single most useful thing you can do this week if you've been putting this off. If this helped, please like this video and subscribe. I'll be breaking down one estate planning mistake every single week, and the next one might be the one that actually has relevancy to you. Thank you again. Take care.